On Tuesday, June 18th, the Karen Read trial continued with day 27. Unlike what we've been experiencing over the last 2 months, today had no testimony in front of a jury. Instead, it was all voir dire of 3 witnesses that the defense is hoping to get admitted as experts in their case in chief. Those are Dr. Marie Russell, Dr. Daniel Wolfe, and Dr. Andrew Rentschlner. Specifically, the hearing was for the prosecution's motion to exclude these 3 witnesses. And the main substance of the hearing was voir dire of all 3 so that the parties and the judge could explore the witnesses' qualifications and the proposed scope of their testimony. In this video, we will get into all of that, including the arguments by both sides on the motion and what the judge has decided so far. Bottom line up front, I think the qualifications for all 3 of these proposed experts are insanely impressive, and to exclude any of these 3 would be, in my opinion, reversible error. The jury has to still have questions as to what actually happened in this particular case because the rest of us still have those questions. And if these experts have the proper qualifications, which I believe they overwhelmingly do, and their testimony is going to be helpful to the jury, once again, I think it would be, then they should be permitted to testify. Watch until the end to see why I think so, and then I want to know what you think. Let's get into it. Okay, so before we get into the actual voir dire, let's first talk about the prosecution's motion and the arguments that went back and forth on it. The motion was a motion to exclude 3 proposed defense expert witnesses, and the prosecution basically had 2 main arguments. First, they argued that the defense was way too late in offering these witnesses as experts since they missed the cutoff deadline for presenting expert witnesses to the other side. Here, there was a reference to a Rule 14 violation. This is talking about discovery rules. When it comes to litigation, whether it is criminal or civil, there's a whole set of rules to follow as to what, how, and when to request and turn over information to the other side. This includes documents, answers to different types of questions in Word format, in depositions, and more. So there are certain deadlines that the 2 sides generally have to meet when handing over information to the other side. And then there are also certain requirements for information that is later discovered and also having to turn that over at some point to the other side as well. And this includes the identification of expert witnesses as well as turning over expert reports to the other side so that they can prepare for their case in chief. And this includes the identification of expert witnesses and turning over expert reports so that the other side can adequately prepare for trial. The idea behind all of these discovery rules is to ensure fairness in the system. You don't want one side improperly sitting on information that in all fairness should be given to the other side so that they can prepare their case. Because really by the time you get to trial, there really shouldn't be any surprises. If one side does surprise the other during trial with information that they had for a certain amount of time or had every reason that they should have had, that could very well be a violation of the discovery rules. And in Massachusetts, that's referred to as a Rule 14 violation. So in this situation, the Commonwealth is arguing that the defense has violated Rule 14 by offering these proposed experts so late in the game. They say that the defense first mentioned them partway through the trial and that this leaves the Commonwealth without a way of properly preparing for these witnesses. And so they want these witnesses to be completely excluded from this trial altogether. The defense, of course, argued otherwise. They say that all 3 of these witnesses were basically just as much of a surprise to them as they were to the prosecution. 2 of them, Dr. Wolfe and Dr. Rentschlner, are accident reconstruction experts who the defense said appeared for the very first time in the federal grand jury hearing that just very recently happened. Alan Jackson even said that they were so new to the defense that they still hadn't even had a chance to have a one-on-one conversation with these 2 witnesses about their opinions. And as for Dr. Russell, apparently they had only gotten in contact with her on something like May 17th through an intermediary. Now, initially in this hearing, Judge Cannone seemed to imply that she didn't see a Rule 14 violation as to the 2 proposed experts from the federal grand jury hearing. And that may simply have been because it was maybe easier for her to understand the timing on that one. For Dr. Marie Russell, however, Judge Cannone said early in the hearing that she saw there likely was a Rule 14 violation because of the way she thought the defense had reached out to Dr. Russell. This later turned out to be incorrect, however, but regardless, Judge Cannone found that the defense had violated Rule 14 by not offering Dr. Russell earlier. I very much disagree with that conclusion, but I will talk a little bit more about that later in this video. The point is, Judge Cannone basically said that because of the violation, she needed to figure out what was the appropriate remedy. Now, when it comes to discovery violations, judges have a number of options for a remedy when they do in fact find a violation. During the pretrial litigation process, before we are there at trial, this is usually going to be something like monetary sanctions, where the violating side has to pay for all of the attorney's fees and the costs that the other side had to spend to argue to get that information. But But sometimes a judge will choose something much more extreme, like going to basically what is the most extreme option, which is excluding testimony from trial altogether. We actually saw this happen in this particular trial already with Trooper Paul's testimony when the Commonwealth tried to have him render an opinion during his direct examination about whether Karen Reed's taillight was broken by getting in contact with John O'Keefe's Traverse. They wanted to have him watch the ring footage from 5 a.m. on January 29th, 2022, and have him give an opinion from there. However, none of the disclosures or reports or anything coming from this witness or from the prosecution indicated that they had any intent for him to give that kind of an opinion before this exact moment. That was sprung on the defense with literally zero warning when the witness was already on the stand, which left the defense zero time to prepare to cross-examine him on that point. So Judge Cannone properly excluded that testimony from the trial. But like I said, this is an extreme remedy. And the reason why it was appropriate here is because there was no way that the judge could have used some other alternate remedy to level out the unfairness created by the violation. And that's ultimately what all of this is about. Fairness and ensuring a level playing field. Discovery sanctions are not supposed to be about punishing one side for playing dirty. It's about maybe discovering that one side did something that created an unfairness, and then the remedy is all about rebalancing so that the other side has a fair shot once again. And so here, as the judge sees it anyway, there's an unfairness that was created by the discovery of Dr. Marie Russell at this hour. The unfairness would be the fact that the prosecution didn't have much, if any, time to prepare or respond to the witness's testimony. So here, I think that the judge basically saw two different remedies, which she referenced at two different times in the hearing. The first is allowing the prosecution to do a completely open-ended voir dire of Dr. Russell ahead of her testimony on the stand so that the prosecution could explore as much as they wanted about her background, her opinions, the scope of those opinions, and what she based them off of, etc. The defense really wanted to limit this, arguing that this would allow the prosecution essentially two bites at the apple, so to speak. But I think that the way that Judge Cannone saw it, this was one way of allowing the prosecution to essentially prepare for the potential ultimate cross-examination to the extent that they'd be otherwise allowed. Also, the other remedy that the judge hinted at was the possibility of allowing the Commonwealth to introduce a rebuttal expert witness to combat Dr. Russell's testimony. So if she does allow Dr. Russell to testify, I think that it's likely that we'll see the Commonwealth present one more expert on rebuttal. Okay, so what was the second argument to exclude these witnesses? Here, the Commonwealth argued that they didn't have enough information on these witnesses to determine if they are qualified to testify as experts under what's called the Daubert Standard. Now, when I say Daubert Standard, I'm referring to one of two tests that the courts will use to qualify a witness as an expert. Think of it this way. Any witness who testifies in any kind of a trial is going to be considered by default a lay witness. Lay witnesses can testify about things that they observed in the past with their five senses: what they saw, what they heard, what they smelled, what they tasted, what they touched. They cannot give an opinion on something because the court will consider that to be speculation. Experts, on the other hand, can give an opinion so long as that opinion is within the scope of their area of expertise. For example, you can't have a brain surgeon giving an opinion on whether a rocket launch observed all safety standards, but you can have an expert from NASA do so. Now, the other difference between these two types of witnesses is lay witnesses, generally speaking, are not allowed to watch or listen in on the testimony of other witnesses. And the reason for that is because we don't want them lining up their testimony with other witnesses, either purposefully or subconsciously. On the other hand, experts are allowed to consider the reports of other experts as well as testimony and other evidence in the case. We don't really care so much about them lining up their opinions with other experts because their opinions have to be based on sound reasoning. And that's what's going to ultimately be tested really more than anything when they are testifying. So in order to testify as an expert, the witness has to be properly vetted by the court so that they can decide whether or not it will help or hurt the jury in trying to understand the case and make the determinations that they ultimately need to make. And like I mentioned earlier, there are actually two tests that the courts might use. Those are the Frye test and the Daubert test. The Frye test, or the Frye Standard, is the one that's generally considered the lower bar to meet out of the two. Under that standard, an expert opinion is admissible if the scientific technique that makes the basis for the opinion is generally accepted as reliable in the relevant scientific community. And then there's the Daubert Standard, which has a higher bar to meet and is the more common test you see in most states, like Massachusetts. This one lists a bunch of factors that courts should consider to allow the expert to testify in the field of question. These factors will include First, whether the expert's technique or theory can be tested or assessed for reliability. Second, whether the technique or theory has been subject to peer review or publication. Third, the known or potential rate of error of the technique or theory. Fourth, the existence and maintenance of standards and controls. And fifth, whether the technique or theory has been generally accepted in the scientific community. Now, one thing that is important to keep in mind is that the U.S. Supreme Court has stressed that courts should be more open to admitting expert testimony when there's basically any kind of an ambiguity, and that in any case, they should rely on a tough cross-examination by the other side. As an example, we saw exactly how that can play out with Trooper Joseph Paul's testimony on days 25 and 26 of this trial. Sometimes it does help a jury more to allow one side to bring in a weak expert and just let them get trashed on cross in front of the jury. It's essentially referencing the law of FAFO or FAFO, however you want to pronounce it.
See, as you can see, the more you around, the more you're going to find out.
Anyway, the Commonwealth essentially argued in their motion that they needed an opportunity to determine whether or not these proposed experts satisfy the Daubert requirements to testify as experts. The defense argued in response that these witnesses were more than qualified based on their education and experience, as is visible in their CVs or curriculum vitae. Regardless, Judge Cannone determined that in the end, voir dire was appropriate to make that determination. So in the end, the judge said, let's hear from these witnesses now, and I'll make the determination as to whether they can testify, and if so, how much they can testify about. She also said that the voir dire would go not just into the background of these witnesses, but also into the proposed opinions that they would give as well. And on top of that, all of the sources that they relied upon to make those opinions. So, what did we learn about these witnesses during this hearing? The first proposed expert was Dr. Marie Russell. Her proposed area of expertise is in injuries to the human body, most specifically dog bites. I will just say I was impressed with all three of these witnesses, to include Dr. Russell. She's a retired ER doctor with decades of experience in hospitals in the Los Angeles area, primarily LA County Hospital, also known as USC Medical Center. This is important because as an ER doctor in such a big hospital and in such a large metropolitan area, she would have seen the full array of injuries, to include dog bites, auto accidents, gunshot wounds, and more. She also has extensive experience as a consultant for the LA County Coroner's Office, so she can also distinguish between what injuries look like on a body that is alive and one that is no longer alive. She has also spent a ton of time on the California Medical Board and has been a professor for a long time. She also has had a bunch of her stuff that was published, both in articles, as well as a reference book for dog bites that's been used nationwide by other medical professionals. To sum it up, she's basically a medical professional badass, who, by the way, also spent some time as a police officer in Massachusetts before she even became a doctor, with some of the most extensive credentials that I think I've ever seen. Also, when on the stand, she gave her opinion specifically about the injuries on John O'Keefe's arm. This is what the prosecution refers to as abrasions and what the defense calls lacerations. Dr. Russell identified what she said is a dog bite near the elbow and parallel scratches from dog claws throughout. She said that all of these injuries on John O'Keefe's arm were caused, in her opinion, by a large dog. Now, in terms of what she reviewed, it sounds like she reviewed basically everything except for the dog DNA analysis and Terry Kuhn's testimony from the UC Davis Veterinary Lab. So I think that if Judge Cannone does allow her to testify, I don't think she's going to allow her to render an opinion on the dog DNA testing. That is, unless Lally decides to ask her about it on cross, of course. The judge also did say that she likely would not allow Dr. Russell to testify about an opinion saying that these injuries were not caused by an auto collision. Personally, I disagreed, since Dr. Russell does appear to have extensive experience with injuries also resulting from auto collisions, but the defense basically said, doesn't matter, we have another expert for that anyway. Now, before we turn to the other two witnesses, there's one more important thing to go over. Remember how I said earlier that Judge Cannone decided, basically at the beginning of the hearing, that the defense probably violated Rule 14 as to Dr. Russell's appearance in this trial? Well, that is only a correct determination if the defense did something like withholding information, for example, the identity of an expert. But you can't withhold information that you don't actually have. And so when Dr. Russell was on the stand, she was asked how she got involved in this case.
So who contacted you about this case?
I contacted a district attorney that I had worked with in the past. We were discussing a different case, a case that I autopsied in 1995. And I mentioned that I heard that there was a case in Massachusetts that might have been being handled by one of his colleagues, his former colleagues, and that there was an issue of whether something was a dog bite, and that I might be able to help in that case, to clarify.
And so when you were provided this material, what is it that you were specifically asked to do?
To look at the wounds and the reports and the materials that were sent to me and render an opinion.
And so before you had even been provided any material, before you had even looked at anything, you had already heard information related to there being a dog bite involved in this case, correct?
I had heard that there was a controversy, that there's some certain wounds could have been a dog bite versus perhaps inflicted by a motor vehicle. That's what I had heard.
So, ma'am, what I'm really trying to get at, Doctor, is sort of the timeline. Okay, so you hear about this. When was that?
Sometime just before May 17th.
So sometime just prior to that, you hear about some controversy in a case in Massachusetts involving a dog bite. On May 17th, you get reached out to by who specifically?
His name is John Lewin. He's an attorney in the LA District Attorney's Office.
And then who did you talk to after that?
I reached out to him. I said I might be able to clarify. And then he reached out to Mr. Jackson, I believe, and then Mr. Jackson contacted me.
And not asking specifically anything you spoke about, but at some point the discussion came specifically to dog bites, correct?
He sent me the materials. He asked me my opinion.
Sent you the materials, asked you your opinion. When did you provide that opinion?
Probably the next day. Yes, I know it was the next day.
So the very next day on May 18th, you provided an opinion?
Yes.
And was that opinion provided in a written fashion, orally? How was that provided?
Orally.
So you reached out to someone shortly before May 17th, spoke to Mr. Jackson on the 17th, received all the material, and then had an opinion by May 18th.
Yes.
But you didn't write any of that down?
No.
Now, when pressed on how she had learned about the case, she said she got an email in her inbox from the Boston Globe talking about it. She said she read the article, she found it intriguing, and decided she had some thoughts that she could share about it. So there are two thoughts that I have about this. First, I've already talked in this case about the power of high-profile cases drawing on information from the public. We've seen it before in other cases like Depp v. Heard, where witnesses stepped forward to volunteer their testimony. And we saw it earlier in this case when the public flooded the defense with pictures of the paramedic Katie McLaughlin spending time with Caitlin Albert, the daughter of Nicole and Brian Albert. So this is another example. Also, a bit more germane to this hearing in particular, this shows that the defense really didn't do anything wrong here. They didn't know about this witness or the impressive body of work experience behind her and her ability to speak intelligently about dog bites. She reached out to them, not vice versa. And as soon as they were made aware of her and decided to proceed with her, they handed over all the information that they had to the prosecution. Nevertheless, Judge Cannone decided there still was a Rule 14 violation in there somewhere. Now, like I said, this would mean she needs to provide some kind of remedy. And so she asked Lally if she were to allow this expert to testify, how soon would Lally be able to find a rebuttal witness? Lally said, probably within a week. So it sounded like if Judge Cannone allows her to testify, that's probably what's going to happen. Okay, so next I'll actually talk about the other two witnesses pretty much together. Those were Dr. Daniel Wolfe and Dr. Andrew Rentschler. They are both accident reconstructionists for ARCA Inc. According to their website, ARCA is a multidisciplinary engineering consulting firm for litigation, insurance, military, sports, and more. They employ forensic engineers who do a wide array of consulting and expert witness testimony. Their clients include law firms, insurance companies, the U.S. military, and the National Hockey League. Both of them have multiple degrees in things like physics and engineering in ways that just make the Commonwealth's accident reconstruction expert, Trooper Joseph Paul, look pitiful in comparison. Now, they both talked about other consultations that they had done for other clients, to include things like how to better design various features in hockey games to prevent some of the bigger injuries seen in NHL players. They also went over the materials that they reviewed in order to reach their conclusions, and that was basically everything that was relevant to the injuries on John and the damage to Karen's SUV. Overall, to me, they both appeared about around 1,000 times more competent than Trooper Paul, as he was highlighted during his testimony on day 26. But anyway, Dr. Wolfe's testimony would be more focused on the SUV damage itself and his opinions on how that damage would have been caused. And Dr. Rentschler's testimony would be more focused on John O'Keefe's injuries and what would be required of his anatomy for those injuries to have been created. All in all, they both showed themselves to be extremely knowledgeable, and particularly in the areas that the jury is going to care about most. And as I've talked about before, expert witnesses who are actually engaging and can explain their area of expertise to the average person are crucial. And both of these witnesses, actually all three in this entire hearing, were incredibly engaging and interesting to listen to. It's like the difference between listening to a boring lecture or a really interesting podcast or a TED Talk on a subject that maybe you don't know much about but find fascinating once they get into it. So what did Judge Cannone ultimately decide? Well, she did not come to any concrete decisions on anything other than that she saw a Rule 14 violation as to Dr. Russell's appearance in this case. Other than that, she said that she would come to a decision by Thursday as to whether these witnesses can testify, and if so, the proper scope of their testimony. Personally, I think they should be allowed to testify. The identities of all of these witnesses were a surprise to the defense as much as they were to the prosecution. So to me anyway, there doesn't appear to be any gamesmanship by the defense that would require sanctions. Remember, the U.S. Supreme Court has said that they want courts to be more liberal in allowing experts to testify and to just subject them to a rigorous cross-examination. And here, they are all exceedingly qualified in their relevant fields, and those fields are all recognized areas of study. And ultimately, their testimony will be helpful so that the jury can actually get answers in this case. In comparison, the experts provided by the prosecution so far have been so abysmal, and there's just no way that the jury can be feeling confident right now that they really know with any degree of certainty what happened to John O'Keefe in the early hours of January 29th, 2022. So if the court is actually interested in providing the jury with the relevant information so that they can make the determinations that they need to make based on all of the best information, these witnesses all should be brought in. But those are my thoughts. What do you think? Did you watch the voir dire yourself? What did you think about these three proposed experts? Do you have any reservations about any of them? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more Karen Reed trial coverage, both in daily recaps and gavel to gavel live streaming, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you really want to support the content, consider becoming a member of Byte Club. You can join either through YouTube memberships or by supporting on Patreon, and doing so means that over the long term of this channel, we can continue to devote all kinds of intensive resources to trials like this one and other interesting legal topics. Otherwise, see you on day 28.